You can still win your personal injury case even if the accident was partially your fault. Here's how Florida law actually works. I'm Avita Samaru, and one of the biggest myths that I hear is that if you contributed to the accident at all, you cannot recover anything. And that is completely wrong. If you are less than 50% at fault for an accident, you can still recover. Florida is a modified comparative negligence state. That means your compensation gets reduced by your percentage of fault so long as you're not more than 50% at fault for the accident. If you're more than 50% at fault, you don't recover anything. Let me give you an example. Let's say you were texting while driving and you get hit by a drunk driver. The jury might find that you were 30% at fault for the accident and the drunk driver was 70% at fault for the accident. If your damages totaled $100,000, you would still recover $70,000. But on the other hand, if the jury found that you were 51% at fault for the accident, you wouldn't recover anything. The key is proving that the other party had most of the responsibility for what happened and you had very little to no responsibility. The insurance companies understand this law and they will try to shift as much responsibility to you as possible to avoid payment altogether or to pay as little as possible. That's why having an attorney who understands comparative negligence is crucial to the success of your case.